Welcome to this explainer. Today, we're unpacking Case CCT 36/03, the Limpopo school dispute and the rule of law. Now, this is a truly fascinating legal journey. We're looking at a dispute that started over a single job opening at a local high school. But, believe it or not, it spiraled all the way up to the Constitutional Court of South Africa. And it didn't just end with a simple ruling on who gets the job. Oh no. It ended with one of the most blistering public warnings ever issued to a government department. So as we dig into the core of this case, I want you to keep this one massive question in the back of your mind. What happens when the government simply ignores a court order? We're going to explore the dramatic climax of this dispute, where the highest court in the land literally had to step in and remind the state that absolutely nobody is above the law. Part 1. 2 candidates, 1 position. To understand how we get to that dramatic warning, we really have to start at the origins of the dispute at Settlers Agricultural High School in Limpopo. The core conflict here is incredibly clear. On one side, we have the school's governing body. Under the law, they're tasked with recommending a suitable candidate for a vacant principal position. They recommended Mr. Gerhardus Petrus Viljoen, a white male. But on the other side, we have the head of the Department of Education in Limpopo, who decided to bypass that recommendation and instead appointed Miss Mashamaite, a black female educator. As the Constitutional Court noted, this highlights a really complex tension, the intricate interrelationship between a local governing body's right to make decisions for their own school and the government's vital need to push for transformation to overcome historical racial and gender imbalances in education. 2 distinct mandates clashing directly over 1 principal position. Part 2. The court fights begin. Naturally, this profound disagreement didn't just stay in the principal's office, right? It quickly escalated from the school grounds to the courtroom. In June of 2002, the school and its governing body immediately went to the Pretoria High Court. So step 1. By June 2002, the judge ruled against the department. He set aside Ms. Mashamaite's appointment, ordered the state to appoint Mr. Viljoen effective July 1st, and ordered the department to pay the legal costs. Now, the department pushed back. In step 2, they asked the High Court for leave to appeal. Denied? So they went higher. Step 3, they petitioned the Supreme Court of Appeal, or the SCA. But in November 2002, the SCA also dismissed their application. So the department lost at every single initial level, effectively cementing Mr. Viljoen as the school's principal. Case closed, right? Well, actually, not exactly. Part 3. The 9-month delay. We're going to shift our focus a bit away from the underlying hiring dispute and instead look at a monumental procedural error that completely derailed the government's case. To understand what happened next, you've got to know this crucial legal concept, condemnation. In law, there are strict deadlines for appealing a case. If you miss them, you have to ask the court for condemnation. Basically, you're begging for forgiveness. It's kind of like trying to return a clearly expired item to a store for a refund. The store doesn't have to take it back. You have to give them a really, really good reason why they should bend the rules just for you. And here, the Department of Education was asking the Constitutional Court for a massive favor. And I mean an incredibly massive favor. The SCA dismissed the department's appeal in November 2002. And then, the department just went entirely silent. It wasn't until August 2003 that they suddenly filed an application to the Constitutional Court. That is a 9-month gap. In legal terms, that's an absolute eternity. So what was the department head's excuse? Well, he claimed he mistakenly thought the November decision was final and that his only option left was to try and change the actual legislation. He literally just let it sit until June 2003 when he happened to be at a meeting in Cape Town and heard about a completely different court making a ruling that favored his original interpretation of the law. Only then did he scramble to revive this dead case. Part 4. Justice denied by time. So, the Constitutional Court had to decide. Do we grant condonation? Do we forgive this massive delay because the legal question about school governance versus transformation is just that important? The court's reaction was intensely pragmatic. First off, they noted that 9 months is, simply put, an inordinate delay. Second, Mr. Viljoen had been working as the principal this entire time. People's lives had moved on. Third, reopening this dispute now would subject the entire school to massive uncertainty and dislocation. Therefore, the crucial takeaway here is that it was simply not in the interest of justice to proceed. The court firmly told the department, look, you took too long, the water has flowed under the bridge, and you cannot revive this specific case. Go find another way to clarify the law. Condonation denied. Part 5. The rule of law. Now, if the story ended there, it would just be a standard lesson in meeting your deadlines, right?
But this is where we pivot to the shocking revelation the respondents dropped on the Constitutional Court regarding those earlier High Court rulings. 3. That is the number of times the government applicant had simply ignored separate costs orders from the High Court. Back in June 2002, the department was ordered to pay the legal costs of the school. Well, the school informed the Constitutional Court that despite frequent requests, the department just didn't pay. They didn't even respond. They completely ignored the judiciary. And this prompted a severe and immediate escalation from the Constitutional Court bench.
The justices were appalled. They stated powerfully, if governments do not obey the court, they cannot expect citizens to do so. The court viewed these ignored costs not just as unpaid bills, but as a direct active threat to the dignity of the justice system itself. Think about it. If a government department is unhappy with a decision, sure, they can appeal it, but simply refusing to pay court-ordered costs? The court stated that nothing could be more demeaning to the effectiveness of the judiciary than having government structures just straight up ignore their orders. The Constitution explicitly states that court orders bind all persons and organs of state.
The consequence of ignoring the courts here was incredibly dramatic. The Constitutional Court didn't just scold the department head. No, they went right over his head to the absolute highest provincial authorities. The court took the extraordinary step of ordering the Limpopo member of the Executive Council for Education and the premier of the Limpopo province themselves to personally investigate this failure. And it wasn't just a casual, open-ended request. The court set a hard deadline, October 16, 2003. They demanded a report back to the highest court in the land, proving that the orders had been paid and fully complied with. It was an absolute judicial flex, proving that no individual, and certainly no government department, is above the law.
And that brings us to our final thought. The Limpopo school dispute is a fascinating look at the clash between local governance and state transformation goals, for sure. But more importantly, it's a stark reminder of how fragile our systems actually are. So we leave you with this question to ponder. If the ultimate referee is ignored, how can the game continue? Procedural deadlines and universal respect for court orders aren't just annoying legal red tape. They're the absolute bedrock of a functioning society. If the state doesn't play by the rules, the whole system collapses. Thank you so much for joining us for this explainer. Keep asking those big questions, and we'll see you next time.